Thank you, Mr. Chairman. Earlier this year, our subcommittee heard dramatic testimony that in Colorado alone, we could add the equivalent generating capacity of the Glen Canyon Dam. That's enough electricity for about 1.5 million homes, simply by placing small generators into existing federal conduits. Extrapolating for the entire nation, this could mean literally tens of thousands of megawatts of clean hydroelectricity, the equivalent of dozens of Glen Canyon-sized dams. But we learned this isn't happening because federal regulations have made it economically infeasible to do so. Endless regulatory delays and exorbitant permitting fees literally double the cost of these projects, making them cost prohibitive. There is no environmental protection added by subjecting these simple installations to a costly, comprehensive, and duplicative NEPA review process. The canals and water delivery pipes are already off-river. They're utterly devoid of any species, endangered or otherwise. Even FERC, a bastion of regulatory excess, agrees that these studies are unnecessary on similar non-federal facilities. Our nation desperately needs affordable electricity. It desperately needs permanent jobs, but to get them, it most of all desperately needs common sense restored to its government. Congressman Tipton's bill, H.R. 2842, does so by providing a comprehensive authorization for the placement of these small hydroelectric generators in existing Bureau of Reclamation conduits. It invites existing operators and users to invest in these generators at no public cost. It provides a streamlined one-stop permitting office within the Bureau of Reclamation to expedite these projects, and it exempts the installation of generators from the costly, time-consuming, and pointless NEPA process where there is no conceivable environmental impact involved. So let there be no mistake about the significance of this measure. At zero public expense, it has the potential to add the equivalent electricity of dozens of Glen Canyon-sized dams around the country. I'd yield the balance of my time to Congressman Tipton.
Thank you, Mr. McClintock, and I'd like to thank the Chairman for convening today's hearing and including my bill, H.R. 2842. This legislation is a win-win for clean energy and for rural jobs. By reducing excessive regulations and red tape, this bill can provide considerable amounts of new clean energy to the grid while helping to create new jobs. Many rural water and irrigation districts and electric utilities in Colorado and other western states seek to develop hydropower on Bureau of Reclamation water canals and pipelines. But overburdensome and unnecessary regulations stand in the way and discourage investments in these projects. This legislation seeks to remove one major economic handcuff, unnecessary environmental analysis. Even though reclamation conduit hydropower units would already be on disturbed ground within existing facilities that have already undergone federal environmental review, another national environmental policy or NEPA analysis must also be done in this case under existing regulations. When asked during the legislative hearing on this bill whether it would harm the environment, the response from Chris Trees with the Family Farm Alliance was very telling. He commented that the Colorado River Water Conservation District and the Family Farm Alliance simply wouldn't be supporting it if it were true. This is an opportunity for us to be able to create jobs, to be able to create clean energy, to be able to show common sense out of Congress when it comes to regulatory policy. Mr. Chairman, I appreciate this time and ask for support of this legislation.
Gentleman yields back his time. As Mr. McClintock yield back his time. Chair recognizes the gentlelady from California, the ranking member of the subcommittee, Ms. Napolitano.
Thank you, Mr. Chairman. And H.R. 2042 seeks to generate more hydropower at existing facilities by developing conduit and in-canal hydropower, which we totally support. The general intent is admirable. The increasing of generation of existing facilities with all the renewables that are subject for a lot of discussion. It has been in the subcommittee that I am ranking member of. But this can be done without disregarding the environmental protections. Therefore, we cannot support this bill, as in fact over and over again for years in this committee. We'll argue that this is the regulatory red tape that is preventing the development of more hydropower. The obstacle for development is not NEPA. There must be a clear process in place for the development of hydropower at reclamation facilities. Developers, business people, everybody's looking at clarity and certainty that the project can be developed. and develop soon to be able to add to those great areas that are developing new green energy. But waiving NEPA will not provide that clarity and certainty. I oppose the bill. I urge my colleagues to oppose it, and I yield back the balance of my time.
Is any further member wish to be heard on the bill? If not, we'll start the amendment process, and Mr. McClintock has an amendment without objection. The amendment is considered read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment addresses mainly technical issues that were raised during the subcommittee's deliberations. First, it makes it clear that the Power Resources Office is the lead office for policy and procedure-setting activities for the Bureau of Reclamation. The subcommittee heard testimony earlier this year that one potential developer tried in vain to get a consistent answer from the federal agency on how he could develop hydropower at a local canal. He received many answers over his 2-year quest, only to hear contradictory answers with every phone call. He's still waiting for an answer, and he and others deserve a consistent and timely one. This amendment clarifies that agency policy, guidelines, and procedures, as well as final decision-making for implementing conduit hydropower development, reside in a single office. This will undoubtedly reduce agency confusion while allowing local offices to follow uniform guidance set by this office, with the net effect of reduced permitting time. Second, the amendment assures that water users are involved and informed throughout the conduit hydropower development process. There have been instances related to particular Bureau of Reclamation hydropower facility installations where water districts were not notified or consulted on conduit hydropower installation decisions on the canal or pipeline which they operate. That's unacceptable. This amendment improves current law to force the agency to communicate and to provide written assurance that water supplies will not be impacted. Third, my amendment includes the term Water Conservancy District under the definition of irrigation districts that can develop hydropower under the bill. We've worked with the administration and water users on this en bloc amendment, and I would encourage my colleagues to support it and yield back my time.
The gentleman yields back his time. Is there further consideration? The gentlelady from California, Ms.
Thank you, Mr. Chairman, and I understand the argument by my colleague and chairman of the subcommittee. But his amendment makes technical changes as well as addressing just a few of the administration's concerns. However, the legislation will still waive NEPA. And while this may have been one developer, we are not aware of some of the issues that he's talking about, but could it be due to budget cuts? Could it be due to the problem with a certain agency staffer? We don't know. And to be able to waive the whole NEPA process on one specific issue does not make sense. While we support the general premise of the amendment, we cannot support the bill. Yield back.
Further discussion on the amendment offered by the gentleman from California? If not, the question is on the amendment offered by the gentleman from California. As many as are in favor will signify by saying aye. Those opposed say no. Opinion of the chair, the ayes have it. The ayes have it. The amendment is agreed to. Gentlelady asked for a recorded vote. As I mentioned earlier in my opening remarks, my intent was to roll, but I want to dispose of the first bill. So under the chairman's earlier announcement, proceedings on this roll call motion will be postponed until later in the markup. Are there further amendments? The gentleman from Massachusetts has an amendment that was that's in our folders. It was after the deadline, but once again, the benevolence of the chairman is going to allow Mr. Markey to offer that. The chairman is recognized for 5 minutes.
I thank the chairman very much, and I note the generosity and beneficence of the gentleman from Washington State on this issue. My amendment is simple. It would strike the National Environmental Policy Act exemption and give the Secretary of the Interior, acting through the Bureau of Reclamation, the authority to issue either a programmatic environmental impact statement or a categorical exclusion for conduits as applicable. This is a win-win solution that allows for the development of hydropower while at the same time taking into consideration any impacts on the environment. Mr. Chairman, the House has taken 136 votes to date that in one fashion or another undermine the protection of the environment. I believe that here we have a solution that protects the environment, creates jobs, And I urge my colleagues to support this win-win amendment that would allow for the development of hydropower at existing facilities, protect the environment, and create jobs. And I yield back.
Gentleman yields back. The gentleman from California.
Thank you. Mr. Chairman, the entire purpose of this bill is to streamline the process so that these hydroelectric generators can be quickly and inexpensively installed on existing federal conduits. The amendment offered by the ranking member actually undermines the goal and could actually lead to even greater regulatory costs and higher bureaucratic hurdles to overcome. Let me emphasize that the facilities which the hydropower units would be installed have already gone through the federal environmental review process. One witness testified to the subcommittee that installing 15 very small hydropower units on a nearby Bureau of Reclamation canal system could cost over $450,000. That's $30,000 per unit, just for additional NEPA reviews that would ultimately conclude no environmental impacts. The paperwork costs for the actual unit would actually be greater than the actual capital costs of the hydropower units. This bill is very limited in scope. It simply says NEPA is not necessary for conduit projects under 1.5 megawatts. That's a very small facility. NEPA would continue to apply for larger facilities. It would apply to the electricity transmission line that may be needed to transmit the conduit hydropower. Since NEPA is a paperwork exercise, nothing in this bill precludes actual environmental permitting laws such as the Clean Water Act, the National Historic Preservation Act, or any similar state law from applying. Despite the limited nature of the bill, this amendment removes the provision and replaces it with a murky and potentially inconclusive process. For example, the amendment gives the Interior Secretary the discretion to issue a programmatic environmental impact statement on conduit hydropower. This process is usually reserved for a major federal action. Since when did installing an isolated turbine on a man-made canal or pipe constitute a major federal action? In addition, even when a programmatic EIS is completed, each installation will still have to go through an individual NEPA study process. So with this scenario, the amendment does nothing to reduce individual NEPA costs, and on top of that, overlays it with a larger and meaningless programmatic EIS. This actually increases overall costs and would lead to more installation delays. The amendment gives the option to the Interior Secretary to issue a NEPA categorical exemption instead of a programmatic EIS. But the amendment fails to define what kind of categorical exemption must be issued. Would the exemption be for each installation, or would it fit more into a general conduit hydropower installation process? Either way, each installation would still have to go through a bureaucratic checklist before any installation occurs, and a categorical exclusion process would still require the Interior Secretary to promulgate regulations to issue a categorical exclusion policy. And at the end of the day, the Interior Secretary may choose to do none of the above because he simply has the discretion under the amendment. The Interior Department has done nothing on this issue since 2004 when the NEPA regulations were updated. We have little faith that the Department would do anything under this amendment. This amendment falls well short of fixing the problem of eliminating a duplicative paperwork requirement and may actually make things worse by requiring more red tape. I'd urge my colleagues to oppose the amendment.
Is there further discussion? Gentleman from California, Mr. Garamendi.
Mr. Chairman, in support of the amendment, there are literally thousands of miles of canals that the Bureau of Reclamation operates. And in those miles, there are numerous places where there would be no environmental impact for the installation of these kinds of facilities. However, some of those canals go through very, very sensitive areas, and there may very well be environmental issues. The amendment gives additional discretion to the Secretary, who then delegates that to the Department to the Bureau of Reclamation. It makes eminent sense. This allows for a very quick review. Are there environmental issues? Yes or no? No. You got a categorical exemption, you get on your way. But you need to look at these things individually. The language of the bill as proposed with the amendment offered by the author, it just simply ignores the environmental issues that may exist. They may, in most cases, there will not be an environmental issue, But I know some of these canals that go through very sensitive areas, habitats of all kinds, duck clubs, for example. And you want to be careful. The amendment as proposed by Mr. Markey brings to the issue an ability to move quickly, but also the necessity of at least looking at the environmental issues. And therefore, I think the amendment's appropriate.
Further discussion on this amendment? Gentleman from Colorado, Mr. Tipton.
Thank you, Mr. Chairman. I think that it's incredibly important that we understand. There seems to be some dialogue that's going on saying that NEPA is being eliminated nationwide on everything, just listening to the words. Not the case. We're talking about ditches, canals, pipelines. And I share your concern for some of those sensitive areas. The good news of this bill is they'll never be touched. We're just going to have the opportunity to be able to put in these small hydroelectric facilities in already disturbed man-made areas that have already gone through the NEPA process. We're eliminating unnecessary, redundant paperwork. We're going to be creating jobs. We're going to be creating clean energy in this country. That must be our focus. This is just a common sense piece of legislation.
Would the gentleman yield for a moment?
Yes, sir.
I certainly agree with you that you do have man-made facilities, but these programs will require some way to get the power from the facility to wherever the grid happens to be. In that circumstance, you may very well go through some environmentally sensitive areas. I mentioned the duck habitats. For example, in California, these canals go through some very sensitive lands. Now, how do you get the power from that location, and how do you get a road to where that power is? That's where the issue will arise, not the canal and not the facility itself.
Yeah, if I may claim my time back, I have more good news for you, because if it's going to be in those areas, then all of the same rules and regulations still apply. This bill is applying simply to the canals, the conduits that are going to be there. So your concern, while I respect it, is ill-founded.
Will the gentleman yield?
Yes, sir.
Yeah, I just want to point out very clearly that the siting of transmission lines for these facilities is still subject to NEPA. It is simply the installation of the turbines that is exempt, because the turbines are being placed in existing facilities that have already gone through the NEPA process.
The gentleman would yield. If you are correct, Mr. McClintock, then the environmental statement would have to include the total project. That's the law. You've got to include the total project. So if you are applying NEPA to the power line, you've got to take into account the whole project. Now, if you're exempting the power line, then the issue that I've raised would apply. So what we're looking at here is the proposed amendment by Mr. Markey gives the Bureau of Reclamation, which really does want to do these projects. I've seen their requests for proposals, and they want to do the projects. But you've got to be careful, because there are many things just beyond the installation of the turbine in the ditch. I'll yield back. I think I know where this is going to go, but at least I hope I've instructed people about the way these things work.
Is there further discussion on the amendment by the gentleman from Massachusetts? Before disposing of that amendment, the chair recognizes the gentlelady from California, Ms. Napolitano.
Thank you, Mr. Chair. We wish to request unanimous consent to withdraw the request for recorded vote on the prior bill, amendment.
Without objection, the request for a recorded vote on the McClintock amendment is withdrawn. Without objection, so ordered, and the amendment has passed by voice vote. Further discussion on the amendment by Mr. Markey? If not, the question is on the amendment offered by Mr. Markey. As many as are in favor will signify by saying aye.
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 Those opposed say no. No. Opinion of the chair, the noes have it.
Mr. Chairman, can we have a roll call, please?
Roll call vote is requested. Those in favor of roll call will raise their hands. A sufficient number having arisen, a roll call is ordered. Under the chairman's earlier announcement, proceedings on this motion will be postponed until later in the proceedings. The next item. Oh, is there further amendments to this bill? If not, we'll proceed to the next bill. The next item